The moment the news hit, it felt like the floor dropped out from under every governor, attorney general, and gun control office in America. Phones exploded, state officials scrambled, panic spread through every agency that thought they had months, maybe years, before something like this could ever happen. But they were wrong, completely wrong, because in a stunning rapid-fire move, the Supreme Court just sent a shockwave through the entire gun law landscape. An emergency action, one that nobody saw coming this fast, has now positioned the court to dismantle the entire U.S. firearm permit system in one sweeping stroke. And here's the part that's lighting Washington on fire. The Department of Justice and multiple states have just aligned behind the move. That's right. The very institutions expected to fight this are now standing beside it. The ground has shifted under every American. And whether you support gun rights or stricter gun control, one thing is undeniable. The game just changed and there is no going back. This moment didn't arrive quietly. It didn't creep in through procedural loopholes or slow courtroom battles. It roared in like a constitutional explosion, fueled by years of growing tension between state regulations and a Supreme Court that has been steadily, boldly, and consistently rewriting the modern Second Amendment framework. When the emergency filing landed on the court's doorstep, legal analysts expected the justices to pause, delay, or punt the issue into next year. Instead, they fired back with an intervention so aggressive that it instantly signaled a massive shift in the nation's legal direction. This isn't politics. This isn't rhetoric. This is the Supreme Court declaring that the era of discretionary firearm permitting may be reaching its final chapter. The emergency action centers on one core constitutional question. Can a fundamental right require government permission to exercise? For decades, states have answered yes. They built massive structures around licensing, interviews, fees, background checks, training mandates, investigations, delays, and even personal character evaluations. But the court's emergency move indicates that the justices increasingly see a very different picture, one driven by history, text, and tradition, not modern policy preferences. If a right is a right, the court is now questioning whether it can be dependent on bureaucratic approval at all. And that single question has now triggered a national legal earthquake. What truly amplifies this moment is the DOJ's unusual shift. Historically, the Department of Justice has defended federal and state regulatory authority. But this time, in a massive political and legal twist, DOJ attorneys have aligned themselves with the constitutional concerns raised in the emergency request. Their position suggests that the current permit systems in multiple states are inconsistent, unpredictable, and potentially unconstitutional under the latest Supreme Court standards. Their support doesn't just strengthen the case, it supercharges it, giving the court institutional backing powerful enough to reshape the nation overnight. State-level support is equally surprising. Several states have stepped forward to argue that the existing firearm permit networks are legally vulnerable and administratively unstable. These states claim that discretionary systems violate the Bruin framework, discriminate against lower-income applicants, and give government officials too much unchecked authority over a constitutional right. While states like California, New Jersey, and New York are preparing for war, others argue the Supreme Court's emergency action is necessary to restore fairness, consistency, and constitutional clarity. This alignment is unprecedented. Gun rights advocates who long believed they were fighting uphill are suddenly supported by federal and state institutions they assumed would oppose them. Anti-gun organizations caught off guard are issuing emergency statements warning that the permit systems could collapse nationwide before new regulations can be drafted. And constitutional scholars are labeling this moment as the most consequential Second Amendment shift since the court decided Brew. At the heart of the emergency action is a case challenging whether May issue and enhanced licensing frameworks can survive under the court's historical tradition test. The challenge argues that the government cannot impose subjective or discretionary standards to control who may exercise a constitutional right. For months, lower courts have delivered conflicting rulings, some blocking state restrictions, others upholding them. The conflicting decisions created a constitutional crisis, Citizens in different states have wildly different levels of access to the same right. The Supreme Court has now stepped in to end the chaos. Their emergency intervention suggests the majority may be ready to declare that a fundamental right cannot be contingent upon the approval of government officials. If that conclusion is reached, then the entire foundation of modern firearm permitting, licenses to own, permits to purchase, permits to carry, renewal requirements, mandatory character interviews, and more could be declared unconstitutional. Inside state governments, panic is spreading over what happens next. Officials know that if the court strikes down permit systems, millions of Americans will instantly shift from regulated applicants to unrestricted right holders. States built their budgets, databases, and enforcement systems around these permit programs. A sudden collapse would cause legal confusion, enforcement gaps, and massive administrative disruption. But it would also realign gun policy to the Constitution in a way many gun owners have waited decades to see. The DOJ's support adds a powerful voice. The federal government now warns that discretionary systems are prone to abuse, unequal enforcement, and constitutional violations. They argue that a unified national standard rooted in history rather than modern policy preferences is necessary to restore balance. The DOJ rarely takes a position that weakens state power, but this time they claim that the Second Amendment requires it. Their support gives the court cover to issue a transformative ruling that will be nearly impossible for states to defy. The emergency action also raises questions about how the court will handle related issues. Waiting periods, background check delays, sensitive place definitions, magazine restrictions, and training mandates. All of these components are connected to the permit systems currently under scrutiny. If the court strikes down licensing requirements, many of these additional restrictions may also face constitutional challenges. The legal domino effect could reshape everything from urban carry laws to rural hunting permits. Meanwhile, public reaction is explosive. Gun rights advocates are celebrating, calling the emergency action the biggest constitutional correction in modern history. They argue that the permit systems were designed to restrict, discourage, or deny exercising a right that should already belong to the people. They see the court's move as a restoration, not an expansion of freedom. They believe the Constitution is finally being respected after decades of political workaround strategies. Gun control activists, however, are sounding alarms. They fear this decision will lead to widespread increases in gun ownership and carrying in states that previously suppressed it. They warned that eliminating permits opens the door to untrained or unvetted individuals owning and carrying firearms. Legal experts respond that background checks remain intact, but permit-based gatekeeping might not survive. Inside the Supreme Court, the ideological divide reflects years of tension. Justices aligned with the originalist view argue the founders never imposed licensing requirements on firearm ownership. They highlight that rights do not require government permission. Meanwhile, dissenting voices claim modern society demands reasonable regulations. The emergency action, however, makes one thing clear. The majority is prepared to reassert the Constitution's text and historical foundation above modern policy ambitions. This moment is not isolated. It continues a series of major Supreme Court moves that have shifted the balance toward individual liberty and constitutional clarity. Hilaire affirmed the individual right to bear arms. MacDonald applied it to the states. Bruen established the historical tradition test. And now this emergency action suggests the court is ready to address the last remaining structure, holding back full Second Amendment recognition, government licensing authority across America. The implications are enormous. If the court moves forward and issues a full ruling overturning discretionary permit systems, millions of citizens in restrictive states will instantly gain rights they were previously denied. Police departments will need new protocols. Legislators will need new laws. Courts will face new cases. Every system built around evaluating, approving, and denying firearms access will be forced to change. The Supreme Court's emergency action has already changed the national conversation before a final ruling is even issued. It has exposed deep constitutional conflicts. It has triggered political panic. It has energized millions of Americans who feel their rights have been held hostage by bureaucracy, and it has forced every state government to confront a truth many tried to ignore. The Second Amendment is being redefined, restored, and reinforced at the highest level of the judiciary, because this isn't just a legal moment. It's a historic shift, a turning point, a national reckoning. And with the DOJ and multiple states now aligned behind the Supreme Court's move, the message is louder than ever. The era of government-controlled firearm permitting may be coming to an end. A new constitutional chapter is being written right now, and nothing will ever be the